Hi, welcome to the second part of our video lecture series on Module 4-C, which is on land acquisition. All right. In the previous video, we were able to discuss registration in terms of landowners. Also, we have identified already the modes of acquisition. In fact, we have discussed the first two modes of acquisition under RA 6657. In this video, we shall be discussing the third mode of acquisition under RA 6657, which is the compulsory acquisition under RA 6657. All right. It's compulsory, meaning it's involuntary, it's forced against the will of the landowner, and it's the state which takes the property, which acquires the property in against the will of the landowner. Uh, this sounds familiar because this kind of exercise of governmental or state power is one of the three fundamental powers of the state, right? And we have learned that uh, in agrarian reforms, at least within the framework of the laws in the Philippines, uh, it is an exercise of eminent domain and at the same time an exercise of police power. Now, in this portion of the discussion, we shall uh, delve deeper into this compulsory acquisition, which is an exercise of the power of eminent domain. All right, and because it's an exercise of a state's fundamental powers against the properties or land holdings of its private citizens, there must be rules, there must be a procedure that must be adhered to and followed by the state in order to not commit mga violation of the constitution, of the constitutionally guaranteed rights, okay, under the law. All right, so for compulsory acquisition, the format of our discussion would be mainly based on this flow chart. Now, I prepared this flow chart in order for us to see, at least from bird's eye view, how will this process proceed. Okay, note that this is a simplified na flow chart, because first reason, uh, if we try to be too technical about it, it will have so much details to the point that it will not be digestible anymore. Okay. Secondly, since we are discussing this as in a general manner, okay, I think that those mga technical rules will have to be dispensed with. What we need to discuss would be the general procedure, and then we will be inserting matters of jurisprudence. Now, important mga principles for us to remember. All right. So, just a caveat lang, this is a simplified and a digestible na general procedure, na presentation of the general procedure. All right. This is based on DAR Administrative Order number 7 series of 2011. All right. And so our pattern, the flow of our discussion uh, will also follow this flow chart. All right. So if we're ready, we can now proceed with the discussion. Okay. The first point of discussion in this flow chart is identification. All right. Identification, because it has to start somewhere. No, the whole process has to start somewhere, and the whole process cannot proceed without knowing who should be involved, what should be involved, and to whom the process is being undertaken. All right? So, in the process of identification, we have to know, we have to identify first the land. Now, we identify the land through the technical descriptions, which would show the meets and bounds, the location, the address of the land, etc. All right. There are too many technical items in the rules which I will not include. Just we will just be content and satisfied with the notion or with the learning that the land must be identified. Okay, the general mga items to be identified should be, of course, technical description, the meets and bounds, the location, the address of the land. All right. But not only the land, because the whole procedure will have to involve payment of just compensation to some person or to a person. All right. So we also need in this procedure to identify the land owner. All right. The landowner must be identified, whether the identification be voluntary or compulsory through getting ocular inspection, through investigation, no? Voluntary kung nag-register si landowner within the 180-day period as provided by the law. But of course, it's not the land and the landowner lang, all right? It also needs, the whole process also needs to identify, no, to whom will the acquired land be awarded. So the beneficiaries, the qualified beneficiaries, will also need to be identified, and we will discuss in the next module, no, how beneficiaries are identified. Suffice it to say lang karon that as a starting point to the process of compulsory acquisition, these three things must be identified: the land, the landowner, and the beneficiary. All right. So that's the first step. That's the first phase for compulsory acquisition. Okay. Now, having identified the land, the landowner, and the beneficiary, now the process will move towards the issuance of the notice of coverage. All right. The notice of coverage is considered as the first notice in this process. Okay. Notice of coverage just identifies, just informs the landowner that a specific land that he or she owns is considered as covered by the DAR. Of course, based on the definition of agraria of an agricultural land, under RA 6657. All right. Now, as I said, a notice of coverage will will be given by the DAR, will be served by the DAR to the landowner. All right, and it's the first notice that the DAR will send to the landowner, because under the procedure for compulsory acquisition, we require, or the rules require, a two notice requirement. No, it's not. I did not use twin notice requirements in order for us not to confuse it with another concept in another subject. All right, let's just call it two notice requirement, because there are two notices here issued in two different times. Okay, the first notice is the notice of coverage, and the second notice is the notice of acquisition, which we will discuss later on. The nature of the two notice requirement is that this is part of granting administrative due process. All right. Due process, meaning that the person affected, the person concerned, is given the opportunity, diba, to be heard, opportunity to contest, just the opportunity, no, contest a governmental act. And in this case, this notice of coverage before the notice of acquisition is given is part of that kaning administrative due process. And the purpose, as I've said, the purpose is to grant the landowner the opportunity to contest sa coverage, and if not, if di siya ganan mo contest sa coverage, at least to exercise, all right, retention rights upon knowledge of the coverage, upon knowledge of the notice of coverage. All right. Now, that's the first notice. The notice of coverage just means that the DAR considers your landholding as covered under RA 6657, and therefore you are being notified as the landowner. You're being notified that your land is covered, and you have a choice to contest it or to exercise retention rights. All right. But then after notice of coverage, the DAR will have to confirm its theory. I mean, the DAR will have to make confirmatory ng mga procedure such that this land subject of a notice of coverage will be confirmed that really this is within the coverage of RA 6657. So the DAR will have to conduct public hearing, all right? We'll have to conduct investigation, further investigation, and inspection, all right? This is called technically under the rules field investigation, all right? The purpose is somehow confirmatory because beforehand, in finalizing the database, the list of covered lands, investigation, ocular inspection were already done. All right, but after the notice of coverage, the DAR will have to confirm, to confirm the theory that the land is covered. Okay, to confirm that the data that they have is correct, meaning also to confirm that this land is this big, to confirm the meets and bounds, the location, etc., etc. In fact, the rules mentions about the cylindrical na mga kaning marks, no, we call that muhon, no, in the province. These cylindrical marks are placed in areas, and these cylindrical marks they signify the meets and bounds, all right, and also with the use of mga recognized mga geodetic practices, and because it this field investigation requires the knowledge of recognized geodetic practices. Usually ang mag-field investigation are personnel of the DAR who are geodetic engineers or are trained to practice kanang geodetic engineering. All right? Very technical na, okay? Not anymore on the matter of law, so we won't dispense of the technical side of the matter. All right? So just know lang na in this field investigation, it's for confirmatory purposes, not only of the land, the status of the land, but also the measurements of the land, the location, the lands, the meet and bounds, etc., etc. Okay, and then in this field investigation, public hearing, public conference may also be called. In such a case, the parties will have to be invited, no, landowner, the beneficiaries, the neighboring mga people, they are called, they are invited to that conference, and in that conference some things will have to be clarified. All right, the technical, the details would be too technical, so we will dispense with the details. Okay, so long as we know lang na after notice of coverage there is field investigation, which is technical in nature, all right, for the purpose of confirming the data that DAR has, confirming the meets and bounds, all the crucial information regarding the land that is to be acquired by the state under compulsory acquisition process. All right. Uh, and so after that, after this confirmatory procedure, no, na naman tayo notice of coverage, uh, after this confirmatory procedure, confirmatory phase of the process, now it is apt, it's appropriate to issue a notice of valuation and acquisition. And now here, this is the second notice that we mentioned. Okay, it's the second notice of the two notice requirement. The first notice is the notice of coverage, and the second notice is the notice of valuation and acquisition. Okay, what's this? As the name suggests, notice of valuation and acquisition. It means that this land was issued with a notice of coverage, all right, and confirmatory procedures have been done in this on this land, and this land, upon perusal of the available data from the DAR, has been initially valued by the DAR, meaning there's already a value attached to the property. And then this land, which has been covered by which is covered by the law, subject of a notice of coverage, and costs this much, will be acquired by the state, will be acquired for purposes of agrarian reform. Note this notice of valuation as a rule, okay, it must be like summons, all right, it must be personally served to the landowner, no? And rightly so, because it's the landowner, no? Kung kinsay landowner that who appears in the records of the DAR must be the one personally served with the notice of valuation and acquisition. And rightly so, because he's the one or she's the one being affected by the acquisition. All right, but of course there are times when the even upon due diligence, even upon substantial investigation, the government cannot ascertain who the landowner is. All right, and in such a case, the rules provide that the DAR may resort to service by publication. Okay, if the DAR cannot locate, cannot ascertain the owner for this certain agricultural land, all right, despite substantial investigation, despite due diligence, then under the rules, DAR is allowed to resort to service by publication. All right, but that's just as a matter of exception. Okay, the general rule remains that notices of valuation and acquisition must be issued, must be served personally to the land owner. All right, now in addition to service, okay, because service is different from posting. Okay, posting here means that the said notice of valuation and acquisition will also be posted in the designated mga conspicuous places. No? It under the law, it's not just the term conspicuous places. All right, the term, the rules provide for specific good ng mga designated places, but these places we will not enumerate anymore. Okay, these places, I surmise, are identified to be the posting sites because these places are conspicuous places like Hall of Justice, Barangay Hall, etc., etc. All right. Now, what's the importance of valuation here? No, it's just is it just an estimate of the DAR Is it just for the purpose of the DAR coming up with something, some figures in that notice of acquisition, and then gives that notice of acquisition some form of legitimacy? Okay, not just that though, because under the rules kaning notice of valuation and acquisition, specifically kaning portion on valuation, this is considered as the initial offer. Okay, this is the initial valuation of the DAR, and you are given this notice of valuation. That notice of valuation, that portion, is considered as the offer of the DAR. Now, the initial offer, initial amount that the DAR is willing to pay the landowner for the covered land. All right, and therefore this valuation, it's indispensable in this notice. All right, because without valuation, there's no initial offer. Okay, and if there's no initial offer, the landowner will have no basis for replying, no basis for either accepting or contesting, and therefore the whole process, in terms of compulsory acquisition, will be irregular. Okay, uh, speaking with irregular na process. All right, because these two notice, this two notice requirement is treated, all right, and subject of discussion in these two cases. All right, because there are times, admittedly, DAR will commit mistakes. No? There are times where the DAR will fail to comply with the two notice requirement. The DAR perhaps would just issue a notice of notice of valuation and acquisition without the first notice. All right, or the DAR may give out first notice but there's no second notice, or it may be that there's first notice and second notice, but the second notice is defective, it's incomplete. Okay, so that it was asked, Supreme Court was asked in one case, in Rojas versus Company, Rojas and Company versus Court of Appeals in 1999. All right, whether a violation or non-compliance with the two notice requirement will have the effect of nullifying the proceedings with the DAR. Okay, in the case of Rojas and Company versus Court of Appeals in 1999, the court held first, no, that the violation of the two notice requirement, okay, non-compliance, irregularity in the two notice requirement, are just characterized as purely procedural na mga irregularities. Okay? Because these requirements are found under rules of procedure in administrative cases, according to the court in Rojas and Company versus Court of Appeals in 1999. These non-compliance or irregularities are characterized as purely procedural, and therefore it will not result into a declaration of nullity of the whole proceedings. If at all, this irregularity in purely procedural na mga aspects will warrant the remand of the case from the courts to the administrative agencies concerned, in order for the administrative agencies concerned to be given the chance to correct their mistakes, to correct the irregularities found in this purely procedural na mga matters. All right? That was in 1999. Okay? Because in 2011, the ruling in the case of Rojas and Company versus Court of Appeals was revisited. Okay, revisited by the Supreme Court, and in that case of heirs of the Leste versus Land Bank of the Philippines in 2011, the court said that this violation of two notice requirement is not just procedural. All right, it's not just procedural because the two notice requirement are put in place in order to afford the affected landowner with due process of law. All right, it's due process of law because now you have an administrative rule or administrative process that must be uh, that must be adhered to, must be followed. Okay, otherwise, if this administrative rule or administrative process is not followed, okay, there will be a violation of the due process clause. All right, and when there is a violation of the due process clause under the Bill of Rights, according to the court in the heirs of the Leste versus Land Bank of the Philippines, the whole proceeding is null and void because there is a violation of the constitutional right to due process. And therefore, the act of that governmental entity, that branch of the government, all right, is considered as null and void. Effectively, the case of Rojas and Company versus Court of Appeals is not anymore the controlling rule, because in this case of heirs of the Leste versus Land Bank of the Philippines in 2011, express man kayong Supreme Court in referring to this case of Rojas and Company versus Court of Appeals, and then the holding in this case is clearly, lahi gid siya sa holding in Rojas and Company versus Court of Appeals. Now, the existing rule, therefore, as things stand now, according to heirs of the Leste versus LBP in 2011, non-compliance, irregularity in the two notice requirement, in the two notices, will result into a violation of the constitutional right to due process. And because there's a violation of that constitutional right under the Bill of Rights in the Constitution, the whole proceeding will be considered as null and void. Not just remand, okay? Not just remand, but the whole proceeding is nullified because there's violation of substantive right as guaranteed by the Constitution. It's not purely procedural because a substantive right is involved, a substantive right is infringed. Okay? Now, let's go to the procedure after the notice of violation and acquisition. As we discussed, ang notice of acquisition, notice of valuation and acquisition, it's served to the landowner personally as a general rule, right? And therefore, the landowner will be notified of this notice of valuation and acquisition. And now the ball is in the court of the landowner. All right, the landowner will have to decide what's his or her play, what's his or her approach upon the receipt of a notice of violation. So from this, we can say that there will be at least two fundamental choices of the land on the part of the landowner. It's either the landowner will reply or the landowner will not reply. Ignore niya ang notice of valuation. It's important as soon to be lawyers, to know the advantage of advising your client na he or she should reply. Okay? Because if the client will not reply, automatic na dayon. It will proceed to the next phase. No? The landowner will be considered to have waived the opportunity to reply, and therefore the government cannot be hostage with such inaction, and therefore the government will proceed. No? In fact, streamlined na noon kung dili mo reply, because there's no more contest, there's no more problem with the valuation. Okay, so it's prudent, just in case when you become lawyers, you encounter this a client who asks what would be the proper and more prudent remedy if they receive a notice of valuation and acquisition. So advise that the landowner or the client should reply. All right, because if the landowner will reply, no, there will be at least again two nga paths, two options for the landowner. All right, the landowner in that reply may decline the offer. You remember, the valuation is considered as the offer, and therefore if your client does not want the valuation, decline siya, or if ganahan siya, tanaw niya it's just a compensation, then the landowner, the client may accept. All right, it's important to highlight this procedure nga the landowner may respond, the landowner may signify his or her response to the notice of valuation and acquisition, because under the rules, the response of the landowner must be given 30 days, within 30 days from the notice of valuation. All right, 30 days ang gihatag sa landowner under the rules for the landowner to reply. Okay, if the landowner does not reply within that period of 30 days, then considered niya as wala siya reply, and therefore mo diretso mo proceed sa next phases according to the rules. All right, but if mo reply, of course, mo proceed to whether ni agree or wala ni agree, no? Now, in any case, whether ni reply or not, or if ni reply, ni agree or wala ni agree, the matter now will have to be forwarded to the Land Bank of the Philippines. Okay? The matter now will have to be forwarded to the Land Bank of the Philippines, because the next phases, regardless if ni reply regardless if wala ni reply or ni reply, i-accept in the reply or gi-decline in the reply, regardless ana nila nga mga choices, the direction will be the same. Okay, that's why in all three cases, the matter will have to be forwarded to the LBP, to the Land Bank of the Philippines, because the next phase will involve the payment of the initial valuation. All right, the payment of the initial valuation as just compensation. Now, here in this scenario na wala ni reply, or in this scenario nga ni decline, the offered amount will have to be deposited with the courts. All right? Deposited or consigned with the courts, because the landowner did not reply or did not agree with the valuation, with the initial valuation. So meaning they do not want to accept the initial valuation, they do not want to accept therefore the money. Okay? And so in order for the DAR to proceed, to be able to proceed with the process, i-deposit ang amount, i-consign ang amount with the court. But if the case was accepted, I mean, if the case is such that the offer was accepted, then still Land Bank of the Philippines will have to be the indispensable party in this case, because LBP will now pay the landowner, and then the landowner will have to execute the necessary documents. Okay, to reiterate, regardless if the landowner replies or not, or if nag-reply sa landowner, regardless if gi-decline or gi-accept, in these cases, the next stage should be that the matter will be forwarded to the Land Bank of the Philippines, because now the indispensable role of the Land Bank of the Philippines starts, no? Because as we have learned, the Land Bank of the Philippines is the identified and designated nga financial intermediary of the government in the implementation of agrarian reform. All right? Now, it's important that in these phases, naanay kwarta, naanay money or amount to be deposited or to be paid. All right? Because payment of this money, of this amount, or deposit of this amount is a prerequisite to possession. All right? This initial amount, this initial valuation, therefore, must be deposited, no, for purposes of enabling the DAR, enabling the government to possess the property. Okay? Without without this deposit, or without the payment of the amount, the possession, okay, will be considered as confiscatory. All right? In order for the possession to be consistent with the principles of eminent domain, because when the DAR takes possession of the property, then the landowner will be deprived already of the land. Diba? Deprived na siya sa iyang private property, and therefore there must be, as a condition precedent, just compensation. All right? And in order, no, within the framework of RA 6657, in order for this condition precedent to be satisfied, there must be this payment if you accept, or deposit if no reply, or if ni-reply man gani, rejected ang initial valuation. All right? Note that the amount involved in the payment or deposit here is not the amount that is summarily determined by the adjudication branch of the DAR. No? The amount to be deposited here must be the initial valuation. What's the initial valuation? The initial valuation by the DAR after having confirmed the circumstances of the land, and based on the data and information that they have on the land, on the covered land. All right? Because the valuation through summary ng mga administrative proceeding will have to come after pa. Okay? After pa mag-payment or deposit. All right? Now, in relation to that, in relation to the deposited amount, because if no reply, or ni-reply but rejected, the government will not be taken hostage by the actions of the landowner. No? Agrarian reform will have to proceed regardless of what the landowner feels about the whole process. No, what the landowner will do with the whole process. All right. So in the deposit, all right, it will be deposited in favor of the landowner. Diba? It will be for the account of the landowner. So that in the case of this case of Land Bank of the Philippines versus DARAB in 2010, a question arose. No? Since the deposit is for the account of the landowner who did not reply, or who did not agree with the initial valuation, all right, can the deposited amount be withdrawn by that landowner who did not reply, or by the landowner who rejected the valuation, the initial valuation? The argument of the state is that no, not yet, no, because the whole proceedings not yet completed. No, it will be subject to adjustments, the initial valuation, and just in case the initial valuation will be, just in case the final valuation will be lower than the initial valuation, then the money will already be gone. All right. But the Supreme Court in this case of LBP versus Darab in 2010 ruled that such deposited amount, okay, for the account of the landowner may be withdrawn immediately. Okay? May be withdrawn even in the pendency of the process. Even when there is question on the initial valuation, even when it reaches the court for judicial determination of just compensation, the deposited amount may be withdrawn immediately. Okay? It is withdrawable according to the court even when there is a question on the initial offer, even when the landowner rejects the initial initial offer. Because at that point in time, since there was already a deposit of the money or amount corresponding to the initial valuation, and therefore the first just compensation, okay, and therefore the DAR now is justified to take possession of the property, to take immediate possession of the property. Now, in that case, therefore, the landowner is already deprived of the property. Okay? Na-deprived na siya sa iyang property, sa iyang use, sa iyang beneficial ownership of the property, and therefore it's just and reasonable for the court to allow the landowner concerned to be able to withdraw that amount, no, pending the judicial determination of just compensation, no, because according to the court in this case, to hold otherwise, no, where you have a case of a landowner who is in reality deprived of the property, but cannot yet enjoy the allocated just compensation, at least the preliminary amount of just compensation. In that scenario, according to the Supreme Court, that's an oppressive exercise of eminent domain, which according to the court, it cannot allow. No? According to the court, it cannot allow, because the exercise of the powers of the state must not be exercised to operate prejudice, to operate oppression on the citizens of the state, right? So according to the court in this case, yes, the amount may be withdrawn by the landowner even when there is question on the initial valuation, right? And so, as we said, very important that the matter will have to be forwarded to the Land Bank of the Philippines, because after the reply of the landowner or lack thereof, the LBP, the Land Bank of the Philippines, will have to pay, and this payment, whether deposit or direct na payment, if in case gi accept, will now warrant the immediate possession of the property by the DAR. If you can see here, no, from this, okay, it will lead here. All right? Okay? It will lead here. Okay? Because now there is considered, I mean, just compensation is considered to have been paid. There's already just compensation for the property that is private property that is deprived by the state. Then the DAR, in representation of the representing the on behalf of the government, the Republic of the Philippines, will take immediate possession of the property. All right. Uh, this immediate possession of the property, that's conditioned on payment of just compensation. All right. uh it's important that there must be payment of just compensation through deposit or through direct payment in case you accept, in order for the DAR to be able to immediately possess or take possession of the property. All right? And then afterwards, after the DAR takes immediate possession of the property, then the DAR will request the Register of Deeds to cancel, okay, the existing transfer certificate of title, or if not transfer certificate of title, or original siya nga certificate of title, basta the certificate of title that covers the acquired land, the compulsorily acquired land, will have to be canceled by the Register of Deeds. All right? And as you know, in your land titles and deeds, the purpose, I mean, when the Register of Deeds issues a new TCT, all right, the old TCT will have to be canceled, right? So the purpose of the cancellation of the existing na TCT or OCT is for the purpose of is for the RD to be able to issue new mga certificate of title now in the name of the Republic of the Philippines. Now it is the Republic of the Philippines which owns the land, no, by virtue by virtue of that compulsory acquisition, as evidenced by the new TCT under the name of the Republic. All right. Uh, Here we can say that the acquisition is already culminated. No, the acquisition. Okay, not the whole process, because there may be, even if the existing titles have been I mean, existing TCTs have been cancelled and the new ones have been issued to the Republic of the Philippines, it's possible that contests to the initial valuation, to the just compensation, will proceed. Okay? But in so far as acquisition is concerned, once here, no, na-cancel na ang TCTs and then na-issuean na og new mga TCTs ang Republic of the Philippines, ano na siya, considered na siya as acquired by the state. Okay? Note that in this kind of acquisition, in this cancellation of TCT and issuance of new TCTs, this is somehow considered as a deviation to the general rule that, as you will learn later on in your land titles and deeds, especially in relation to mga voluntary dealings, right? If voluntary dealings man god, that means in order for that dealing, let's say sale, no, contract of sale, in order for the contract of sale to be reflected in the records of RD, and in order for a new certificate of title to be issued and the old one to be cancelled, the owner's duplicate of title, no, held by the registered owner will have to be surrendered, no, will have to be surrendered with the RD, because the purpose there is in order for the in order for the duplicate certificate of title to be also cancelled. All right, because it may be possible, no, if wala na siya nga rule, it may be possible nga na-cancel na ang copy sa RD, na-cancel na ang sa data nila, but the certificate of title held by the landowner is not yet cancelled, not yet annotated, in which case, there is a possibility nga magbaligya again. There's a possibility nga mag-double sale, no? On the basis of that uncancelled na owner's duplicate of title. No? In order to prevent that, in order to discourage that kind of scheme, the rules, the law requires that in order, as a general rule, in order for the TCT to be cancelled and a new one to be issued, dapat ang owner's duplicate of title dapat i-surrender po. Right? That general rule does not apply here. Okay? That means here, in the case of compulsory acquisition, there's no requirement nga mo surrender si landowner sa iyahang certificate of title. Alright? Because this is an involuntary dealing, involuntary man siya, it's considered as a deviation to that general rule nga dapat before mag-cancel, before mag-issue, dapat dapat ang duplicate owner's copy is surrender. Here, it's not required. Meaning, once the government or the DAR asks the RD to cancel the certificate of title subject, covering a land that is subject to agrarian reform, the RD cannot say, oh, where's the owner's duplicate? We cannot cancel this without the owner's duplicate. Alright? Under the law, okay, that's not a requirement, and therefore, even without the surrender, the TCTs, existing TCTs, may be cancelled, and the new ones under the name of the Republic may be issued. Otherwise, if that's the requirement, otherwise the acquisition by the government will be held hostage by the landowners, right? Will be held hostage by the landowners by just withholding their owner's duplicate, because they are the ones who hold the copy, owner's duplicate copy. Okay? And then afterwards, no, issue na og new mga TCTs, the Republic, okay, the government na ang owners anang land. Okay? It's the government now, because acquisition man by the government. It's the government which acquires the property first. Okay? So, that TCT will be in the name of the Republic of the Philippines, and but that portion of land covered by that TCT is for redistribution later on. Alright? It's for redistribution later on, which we will discuss in the next modules. Alright? Okay? Because here now, no, mag-redistribution naman na siya. We will discuss that in module 4-D. Okay? Now, as I said, this will be the culmination, consider siya as culmination of the whole acquisition of properties, acquisition of covered land holdings under RA 6657. But that does not mean that the whole process is complete. The whole process will stop, because there are instances where, especially if the landowner does not agree with the valuation by the DAR, no, nga even when the property has been taken possession na by the DAR, ongoing gihapon ang litigation on just compensation. In ongoing gihapon ang litigation on the determination of just compensation. We will discuss this in the next part of the video. Okay, see you there.